This week's question of the week is as follows. My wife has run up a number of credit cards and she is behind on payments. They are all in her name. My name isn't on any of the paperwork and is not on any of the credit cards. Am I still responsible for the debts just because I'm married to her? As a general rule, unless you have signed an account holder agreement or other document where you specifically agree to pay the debts of your spouse, you would not be responsible for those debts. In fact, there is a specific code section. It's called Tennessee Code Annotated Section 47-18-805 that reads as follows, and I'm going to quote the statute to you. It says that where the applicant for credit is married, the spouse of the applicant shall not be liable other than to the extent common law liability is imposed for furnishing necessaries for any debts, charges, or accounts where the spouse has not signed the application for credit. Now, if you listen closely to that statute that I just read to you, you will maybe pick up that there is a common law doctrine out there that applies to certain debts incurred by your spouse. Specifically, there's a thing called the necessaries rule. The necessaries rule is a common law doctrine that's been established under cases decided in the court system that a provider of medical or other necessary services can have recovery against the spouse for services provided to the other spouse that were necessary to the receiving spouse's health and well-being. Stated otherwise, if a creditor can establish that that creditor provided services to your spouse and that those services were necessary for the receiving spouse's health and well-being, the person from whom recovery is sought that was married to the receiving spouse and that payment has not been made, they could recover the value of those services from you. Most of the cases that I have seen, the creditor uses this doctrine to recover for medical services because there's no question in most people's minds or most judges' minds that medical services are necessary to one's health and welfare. I think it is possible, although I've never seen it used in a particular case, I think it's possible that if a creditor could make the case that there was a bill or a debt owed for other necessary services besides medical expenses, that the other non-receiving spouse could be held liable for the value of those services. But determining whether something is or is not necessary could provide or could be a mountain for the creditor that they could not overcome. In fact, as I just inferred, I've never seen a creditor come after somebody alleging the necessaries rule for anything other than medical expenses. If you are being harassed or a creditor is coming after you trying to collect the bills of your spouse, it would be my recommendation that you schedule an appointment with an attorney who is experienced in debt collection issues, bankruptcy issues, and who has a working knowledge of the statutes that I've been discussing to review your particular problem and determine whether the debts that you are being pursued over would fall under the necessaries rule and whether you could be held responsible for those. I have 26 years of experience in this area of the law. I'd be happy to sit down with you and review your list of debts or review your individual situation with you and determine whether the creditors could hold you responsible for the debts of your spouse. And as always, I would be happy to help you get your life back.
Get your life back. Call the law offices of T. Verner Smith, 423-1888, 423-1888.